In today's lecture, we continue our discussion of the right to life in the International Covenant on Civil and Political Rights, or ICCPR, with a particular focus on capital punishment and the death penalty. We'll also talk about the status of capital punishment in customary international law. Let me begin by showing you a review of a slide from the previous lecture. Here is a provision of the ICCPR, Article 6, Paragraph 1, which enshrines the basic idea of the right to life. Recall also from the previous lecture that the UN Human Rights Committee has adopted General Comment number 6 that interprets the right to life protected in Article 6 of the ICCPR. Now I'm going to run through a number of the other paragraphs of Article 6, many of which deal with issues relating to capital punishment. Here you see the second paragraph of Article 6, which reads as follows. In countries which have not abolished the death penalty, sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of that crime. Now, this provision of Article 6 is a restriction on the death penalty to certain types of crimes and after the operation of certain types of procedures, such as a final judgment rendered by a competent court. The next provision in Article 6, Paragraph 3, speaks to situations involving genocide. And essentially this paragraph says that nothing in the ICCPR in any way derogates from the obligations that states parties to the Genocide Convention have assumed. Since we'll talk about genocide in the next lecture, I'll spend more time on that topic then. Paragraph 4 of Article 6 provides that anyone who has in fact been sentenced to death has a right to seek pardon or commutation. An amnesty, pardon, or commutation of a capital sentence can be granted in all cases. Article 6.5 restricts the categories of individuals against whom a death sentence can be imposed. And it says that death sentences shall not be imposed for crimes committed by those who were below 18 years of age at the time of the crime, nor can they be carried out on pregnant women. The final clause of Article 6 refers to a kind of progressive approach that says this article, with its restrictions and limitations on the application of the death penalty, cannot be cited as a basis for delaying or preventing the abolition of capital punishment by a state party to the ICCPR. Now, when you read all of these clauses of Article 6 together, they raise the following question. What is, in fact, the status of capital punishment in Article 6 of the ICCPR, given all of the provisions that you've just seen? Well, the UN Human Rights Committee, in its General Comment 6, adopts an interpretation that answers that question. And what the committee says in the General Comment is, first, that states are not obliged to abolish the death penalty totally. However, they are required to restrict it in various ways, including in particular abolishing it for the most serious crimes. But the committee goes further and says that the overarching structure of Article 6 refers to the abolition of the death penalty in terms that suggest that it is, in fact, desirable and one way of protecting the right to life. And thus the committee invites information from states in the reporting process on the measures they have undertaken to abolish the death penalty. Now you might be wondering, given this trend toward abolition, if you were the president or prime minister of a state party to the ICCPR and your country had abolished capital punishment, and in addition, you wanted to convince other states parties to the ICCPR to adopt the same policy, how might you use international human rights law to go about achieving that objective? There are a number of answers to this question, but the one that was adopted within the framework of the ICCPR was to negotiate and adopt a supplementary legal instrument known as the Second Optional Protocol that obligates those states that have ratified it to abolish the death penalty in its entirety. And this is, as you can see, a later legal instrument than the ICCPR, which was adopted in 1966. The Second Optional Protocol was adopted in 1989. It entered into force 2 years later, and it currently has 78 states parties, which is about half of those nations that are states parties to the main instrument, the ICCPR. Now, what does this development suggest about the status of the death penalty in customary international law? First, let's recall the definition of customary international law that we discussed in the first week of the course, and that contains two elements: widespread and consistent state practice that is followed out of a sense of legal obligation. Let's look in particular at the state practice requirement. On this slide, you will see statistics compiled by the human rights NGO Amnesty International, which indicate that as of 2012, 2/3 or more than 2/3 of states had abolished the death penalty, either for all crimes except the most serious ones, or in practice through the adoption of a moratorium or suspension of the death penalty. So in all, 140 nations had abolished the death penalty either in law or in practice, leaving 58 states that continue to retain and in some instances use the death penalty. Now, here's another way of seeing that same basic information with the countries of the world coded according to the specific status of whether they have abolished in whole or in part capital punishment, or whether they retain capital punishment and use it. The discussion prompt to this lecture invites you to consider, in light of this pattern of abolition, whether in fact the prohibition of the death penalty is currently required by customary international law. I invite you to take a look at some of these sources, which give more insight and guidance regarding the application of capital punishment in international law.